Let me just say it at the outset that all of us, all Kenyans of goodwill, find corruption that has eaten so much of what we have not seen as the aspirations of the founders of this Republic of Kenya. But be that as it may, it is important that we clarify to the members of the public how the office of the ODPP is created, particularly under Article 157 of the Constitution. To mention is that the office of the ODPP is formed or enacted in law as an independent office, given powers under Article 157 of the Constitution to make an independent decision on when to charge, when to prosecute, and over and above that, to discontinue charges or prosecutions that were continuing before the court. So this is power that we, the people of Kenya, exercising our sovereign authority under Article 1, gave to the office of the Director of Public Prosecutions, which office is currently being occupied by my senior, Mr. Renson Ingonga. Now, during the exercise of this power, there are things that, or facts that the members of the public need to be informed clearly so that they understand how this decision to charge is made by the office of the ODPP. Well, at some time or at some point, when you read the decision to charge guidelines that were passed along by my senior, Mr. Nurdin Haji, while he was in office, and of course in accordance with the Office of the Director of Public Prosecutions Act and the Constitution, the DPP, even sometimes when we have a preponderance of evidence, might be slow at taking action due to probably public interest in a matter. Sometimes the DPP, while exercising his authority to charge or cause the charging of an individual of any criminal offense, sometimes even with the lack of enough or sufficient evidence, he might be slow to make the decision to charge because of the questions about public interest and the proper administration of justice. So that we must underscore, so that when we see any action or inaction from the office of the ODPP, we must be well informed of the background, of the rationale behind the ODPP refusing or declining or taking an action to either cause the charging of an individual or declining to do so. So that must clarify the legal regime that we find ourselves in that gives the ODPP the power to either press charges or decline to press charges. But on the question of charges, well, on a number of occasions when the office of the ODPP is invited to charge or authorize the charging of an individual, many a times we have seen, because the ODPP is charged with the responsibility of guiding investigations in all the investigating agencies, be it the Directorate of Criminal Investigations, be it the KWS, be it the EACC and other government agencies. Sometimes people who are given the responsibility of investigating, and that is the reason why you see so many cases being dismissed in court, is because people who are given the obligation of conducting investigations, many a times they are either negligent on certain aspects of the criminal investigations, or they come up with the investigations that are not complete. For that reason, there has been occasions where the Director of Public Prosecutions has, in exercise of his mandate, directed investigative agencies, particularly the EACC, to go and cover up certain areas so that when the case is taken before the court of law, the case is watertight. But many a times we see the EACC making nonsense or very serious things. The EACC claiming that someone like probably His Excellency, the Honorable Natembeya, has been arrested for pilfering public resources to the tune of billions of shillings. Only for the charge, when it is presented before the competent court of law, for the members of the public to be informed that Natembeya, the Honorable George Natembeya, has only been accused of participating in acts that have been deemed to be corruption-related offenses to the tune of about 1.2 or 1.5 million shillings. So it is important that we stop the games about the fight against corruption all of us want to deal decisively with corruption in this country, but there must be goodwill, especially from investigators within the Republic of Kenya. And I speak so specifically with reference to the office of the EACC. The Ethics and Anti-Corruption Commission comes to me as the weak link towards the fight against corruption. Many a times we know that when the areas have been recommended for them to cover up and investigate, that they end up withholding the file and taking no further action in the file. So we must be very genuine in the fight against corruption. If the EACC is quite clear with its mandate, if it is so determined to taking stern action against people who are engaging in anti-corruption offenses, well, they must be faithful to the people. They must conduct thorough investigations. They should not take, you know, the kind of investigations we are seeing is that the EACC goes, conducts an arrest, then after conducting an arrest, that is the time they are surrendering the file to the office of the ODPP to give directions as to whether this person X or Y should be charged for that offense. Well, we know too well that the DPP is independent, and the DPP, for him to do what is right and just, because his decision is a decision that is ultimately meant to affect the lives of so many people who will be relying on this particular individual that is treated as a suspect to the offense. So, for us to assist the office of the ODPP to protecting lives, to ensuring the proper administration of justice, to ensuring that we protect the public interest, to ensuring that we do not allow the criminal justice system to be abused at the whim and caprice of people who've been given the mandate of investigations. It therefore means that the DPP must be given and accorded enough and sufficient time to peruse through the file, and any recommendations given by the office of the ODPP must be acted upon by the investigator. When we have a situation where the investigator turns sense on top of its head by deluding the members of the public, the unsuspecting members of the public, that the person that is not assisting in the fight against corruption is the office of the ODPP, while we know too well it is the office of the EACC that, number one, fails to make very comprehensive investigations, to do thorough investigations that will give the DPP the impetus and the encouragement to make the decision to charge. So I must end by saying that the EACC and other investigative agencies owes us a duty in doing thorough investigations. They must stop the media play, the melodrama that they continue treating the members of the public, to demonstrate to us, the members of the unsuspecting public, that they have been working. Well, we know too well that they are conducting investigations just for the purpose of the media, so that they can be documented as people who are fighting corruption. Yet we know too well that we cannot allow shoddy investigations to be presented before the court of law, because we even risk public coffers being utilized to compensate people who have been wrongfully charged before the competent court of law. So I urge that the EACC takes its oath of office, takes its duty very seriously. Let us be faithful to the people. Let us report accordingly. And members of the fourth estate, when you are reporting these matters to the members of the public, clarify to the people that the decision made to charge by the office of the ODPP is a serious one. It must be done with a lot of care and circumspection. For one to be presented before a competent court of law. We do not want people's lives to be destroyed because of a decision that will be made by the DPP on the strength of very whimsy investigations. Thank you.
Sunday Standard carried a headline, "The weakest link to criminal prosecution in this country, to the fight against corruption, is the Office of the Director of Public Prosecution." I have been given instructions by Sheria Mtaani to take that matter to court, not to sue the new. The weakest link to the fight against corruption in this country being the office of the EACC. One, Before 2010, before the 27th of August 2010, the office of the ODPP was a branch under the office of the Attorney General. The police were the prosecutors. Kenyans spoke loudly, completely, and said, a prosecutor cannot be an investigator. And Kenyans created the Office of the Director of Public Prosecution under Article 157, which gives the officer sitting there a constitutional tenure of 8 years. That office was clothed with clear instructions that nobody can direct the Office of the Director of Public Prosecution on what to do in terms of prosecuting and approving charges. The Office of the Director of Public Prosecution developed guidelines to look at the threshold, the evidence that is being brought by investigators. Does that evidence satisfy the threshold for a conviction in court? Out of this, very many files that are being presented to the Office of the Director of Public Prosecution have been rejected because they don't meet those standards. The Office of the Director of Public Prosecution approves charges, all of them, the whole country. The DCI sends almost 94% of all the files. The DPP looks at are files coming from the DCI, the whole country. The General Police, that is the OCS, the JDs, General Duties, account for around 5% of those that come. KRA, KWS, and other investigative agencies account for around 2%. EACC has a 2% portfolio of the files that go to the Director of Public Prosecution. Out of 98% of the files that are forwarded to the DPP, you will hear no noise from IPOA, you'll hear no noise from KWS, you'll hear no noise from Kenya Forest Services, you'll hear no noise from the DCI, neither will you hear any noise from the Inspector General Police. What is the biggest problem in the fight against corruption? The law is very, very, very settled that before you arrest, you must have gotten approval from the DPP to arrest, so that you are arresting somebody to take him to court. EACC, a complaint is launched. After 2 to 3 days, they'll carry media, go and arrest a governor, go and arrest a member of parliament, go and arrest anybody, drag him to the offices of EACC. Statement has not even been taken by the complainant. Then that person is taken to Kilimani police station to stay overnight, then is released on EACC on police bond. The investigation will take a minimum of 6 months. The investigations of EACC normally takes 2 to 3 years. Then the file is sent to the DPP. The day the file is being sent to the DPP, EACC will call a press conference and say, we have forwarded 400 files to the DPP. Today is Tuesday. On Friday, the EACC will say, we have not gotten a response from the DPP. The investigations took 3 years. The DPP must look at every file analyze the evidence, then make two things. One, tell the EACC, go and cover these areas. Or approved charges, arrest and charge. The DPP has, I've said, 98% of his work from other investigative agencies, not only the EACC. So the noise we are seeing is purely calculated to depict the office of the Director of Public Prosecution as not working or as being the impediment towards arresting and charging people. The questions I push to the EACC and in the petition we shall be filing through Shadrack Omboi and Sheria Mtaani are: one, what is the conviction rate of the EACC? So that we know the amount of resources government, the citizens are pushing there. What is their success rate in terms of conviction? Number two, they have raised issues that the DPP withdraws matters. Every year, the DPP files a report, an annual report to Parliament. And from the report, the media can check every year, the whole country, a minimum of 3,000 files are withdrawn every year. There's a year they withdrew more than 5,000 matters. Why? Article 157 allows the DPP to review files. And the review can be occasioned by the lawyers, the defense team, writing to the DPP and saying, these are the facts that the investigator failed to have. Relook at that file. The DPP can relook at that file and terminate and request to withdraw that matter. Article 157, sub-article 11, allows the DPP on his own motion. As the case is progressing here at Milimani, the DPP who is in court can look at the witnesses, how they are coming, and recommends a review of that file. And the review can come out that it complies with Article 157.11, that the DPP as the custodian to ensure there is no abuse of criminal justice system will apply for withdrawal. The third issue, and this is very, very critical to the whole country, the DPP has no power to terminate any. Let us be very clear. The DPP has no power to terminate a matter in court. What powers does the DPP have? The DPP will review the file. He will come to the presiding magistrate, presiding judge, make an application to be allowed to withdraw. Give reasons. It is the court that withdraws. Under the old constitution, there was what was called the nolle prosequi, where the DPP could walk in and terminate the matter. Today, a matter will be withdrawn with the leave of the court. I think that's 157.8. With the leave of the court. The DPP does not sit at his Ragathi house and terminates or withdraws any matter. Any matter must be withdrawn of the court. So this narrative that the DPP has been withdrawing matters left and right is not true. The matters, some of them, the media here, you'll look at your records and you'll find some matters the DPP, the courts have rejected the application for withdrawal. And the DPP has been told, proceed. It's not the first time. The DPP aggrieved has gone to the High Court. He's lost. The DPP has gone to the Court of Appeal. The final decision on whose matter will be withdrawn does not rest with the DPP. It rests with the courts. Another very critical issue is the question of the DPP's powers to decide not to charge. An investigator like ESCC, an investigator like the DCI will bring a file. Pole. They do not have the power to decide who to be charged. I know very well, and it is in public knowledge, that the DPP, the ESCC has been fighting to have powers to prosecute. Any prosecutor, neither can an investigator be a judge. Montesquieu provided for separation of power. The ESCC can never, will never, and shall never in a modern democracy be allowed to prosecute. That is the role, a preserve of the DPP. And it cannot change because the best practices worldwide, prosecutors are independent. They make their own decisions, they prosecute their matters. So members of the fourth estate kindly inform the ESCC that they will remain an investigator, just like the IPOA, just like the DCI, just like KRA, just like KWS, just like any form of investigator in this country. And therefore, an attack on the office of the Director of Public Prosecution is baseless. There is no evidence at all to do what they want to do. We know a few petitions have been filed to the Public Service Commission attempting to remove the Director of Public Prosecution from office on flimsy grounds. All those petitions, around 8 of them, have been dismissed because they are asking the DPP to be removed from office purely. His mandate is to charge, and anybody aggrieved that he has been charged, the Judicial Review Division of the High Court is created for you to challenge the decision by the DPP to charge. Those petitions have been dismissed, and we expect many will be filed, but the position is very clear that ESCC to up their game, they do proper investigations, they give the DPP sufficient time, all those files, and we challenge any file that the DPP has told them to cover some areas. Can they bring evidence that they have covered that file and return to the DPP for the DPP to take action? All those files go to the ESCC and they are kept there. So it is our conviction that the weakest link and the conveyor belt for corruption is not the office of the DPP, but the office of the Ethics and Anti-Corruption Commission. Thank you very much, unless there are questions to be asked.
So, under the Constitution, it is only the DPP who can prosecute, and not the ESCC, the prosecutor.
There are two functions exclusive to the DPP. One, to decide to charge. Investigators don't have the constitutional mandate to decide to charge. That is the DPP. Two, prosecution. Only the DPP has the power to prosecute. And the DPP, when I talk about the DPP, is one Renson Ingonga. Any other prosecutor acts in court on delegated authority of the Director of Public Prosecution. Only one person. The Constitution gave one man or one woman the office to prosecute. Other prosecutors, who are around 2,000, 3,000, act on delegated authority of the DPP. So EACC can never touch that. And the DPP does not take instructions. It is actually him who gives directions to the Inspector General of Police and all investigative agencies.